Hello friends, welcome to the Point. In today's session, let's discuss about subordinate courts. The state judiciary, it consists of High Court and a hierarchy of subordinate courts, which is also known as lower courts. The subordinate courts are so called because of their subordination to the state High Court. Subordinate courts function below and under the High Court at the district and the lower levels. Articles 233 to 237 in Part 6 of the Constitution, it makes certain provisions to regulate the organization of subordinate courts and to ensure their independence from the executive. That includes appointment of district judges, appointment of other judges, control over subordinate courts, interpretations and applications of above provisions to certain magistrates. Let's discuss in brief about these provisions. Appointment of district judges. The appointment, posting and promotion of district judges in a state, it is made by governor of the state in consultation with the High Court. A person who is to be appointed as a district judge, he should have certain qualifications, and they are: he should not already be in the service of central or state government. He should have been an advocate or a pleader for 7 years. He should be recommended by the High Court for appointment. And these are the qualifications of a person to be appointed as a district judge. Appointment of other judges. Appointment of a person other than a district judge to the judicial service of a state, it is made by governor of a state after consultation with the State Public Service Commission and the High Courts. Control over subordinate courts. The control over district courts and other subordinate courts, including the position, promotion, posting and the leave of persons who belongs to the judicial service of the state and holding any post inferior to the post of the district judge, it is vested in the High Court. Interpretations. The expression district judge, it includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small cause court, chief presidency magistrate, additional chief presidency magistrate, session judge, additional sessions and assistant session judge. The expression that is judicial service means a service consisting exclusively of the persons who are intended to fill the post of district judge and other civil judicial post which is inferior to the post of district judge. Application of the above provisions to certain magistrate. The governor may direct that the above said provisions that relates to the person in the state judicial service, it would apply to any class or classes of the magistrate in the states. Structure and jurisdiction. The organizational structure, jurisdiction and nomenclature of the subordinate judiciary, they are laid down by the states and hence they differ from state to state, and broadly speaking, there are 3 tiers of civil and criminal courts below the High Courts, and they are shown in the figure depicted here. The district judge is the highest judicial authority in a district, and he possesses original and appellate jurisdiction in both the civil as well as criminal cases, that is in criminal matters. So we can say that the district judge is also the session judge. The district judge, he exercises both judicial and administrative powers. He also has supervisory powers over the subordinate courts in the districts. Appeals against his order and judgment, it lies to the High Court. The session judge has the power to impose any sentence including life imprisonment and capital punishment, which is also called as death sentence. The capital punishment, it is passed by him, is subject to confirmation by the High Court. Whether there is an appeal or not, it has to be confirmed by the High Court, only for capital punishments. Below the districts and session courts stands the Court of Subordinate Judge on the civil side and the Court of Chief Judicial Magistrate on the criminal side. The subordinate judges, they exercise unlimited pecuniary jurisdiction over civil suits. The Chief Judicial Magistrate, he decides criminal cases which are punishable with the imprisonment for a term of up to 7 years. And at the lowest level on the civil side is the Court of Munsif, and on the criminal side is the Court of Judicial Magistrate. The Munsif possesses limited jurisdictions and decides civil cases of small pecuniary stake. The Judicial Magistrate tries criminal cases which are punishable with the imprisonment of up to 3 years. In some metropolitan cities, there are city civil courts and Chief Justice on the civil side and the courts of metropolitan magistrates on the criminal side. And some of the states and presidencies towns, they have established small causes courts, and these courts, they decide the civil cases of small value in a summary manner. Their decisions are final, but the High Court possesses the power of revision. And in some states, panchayat courts, they try petty civil and criminal cases. They are variously known as Nyaya Panchayats, Gram Kacheri, Adalati Panchayats, Panchayat Adalat, and so on. National Legal Services Authority. Article 39A of the Constitution of India, it provides for free legal aid to the poor and weaker sections of the society and ensures justice for all. And Article 14 and 22(1) of the Constitution, it also make it obligatory for the state to ensure the equality before law and a legal system which promotes justice on the basis of equal opportunity to all. In the year 1987, the Legal Service Authority Act, it was enacted by the Parliament, which came into force on 9th November 1995 to establish a nationwide uniform network for providing free and competent legal services to the weaker sections of the society on the basis of equal opportunity. The NALSA, that is the National Legal Services Authority, it has been constituted under the Legal Services Authorities Act 1987 to monitor and evaluate implementations of the legal aid programs and to lay down policies and principles for making legal services available under the Act. So, in every state, a state legal services authority, and in every high court, a high court legal service committee has been constituted, and a district legal services authority and a taluk legal services committees, they have been constituted in the districts and most of the taluks also, so that they give effect to the policies and directions of the NALSA and to provide free legal services to the people and to conduct Lok Adalats in the state. Supreme Court Legal Service Committee, it has been constituted to administer and implement the legal service program in so far and it relates to the Supreme Court of India. And NALSA lays down policies, principles, guidelines and frames effective and economical schemes for the state legal services authorities to implement legal services programs throughout the country. Primarily, the state legal services authorities and the district legal service authorities, taluk legal service committees, etc., they have been asked to discharge some of the functions on regular basis. like to provide free and competent legal services to the eligible persons and to organize Lok Adalats for amicable settlements of the disputes, to organize legal awareness campus in the rural areas. The free legal services include payment of court fee, process fees, and all other charges that are payable or incurred in connection with any legal proceedings. And free legal services, it includes providing service of lawyers in legal proceedings. It also includes obtaining and supply of certified copies of orders and other documents in the legal proceedings. Let's see who are the persons eligible for getting a free legal services. And the persons who are eligible for getting free legal services are women and children, members of scheduled caste and scheduled tribe, industrial workmen, victims of mass disaster, violence, flood, drought, earthquake, and industrial disaster, disabled persons, persons in the custody, and persons whose annual income does not exceed 1 lakh. In the Supreme Court Legal Services Committee, the limit is 1,25,000. And the victims of the trafficking in the human beings or begar, that is a bonded labor. Lok Adalats. Lok Adalat, it is a forum where the cases or disputes which are pending in a court or which are at pre-litigation stage, not at brought before a court or compromised or settled in an amicable manner. So the Supreme Court has explained the meaning of Lok Adalat, that the word Lok Adalat means people's court. This system, it is based on Gandhian principle and it is one of the components of ADR, that is Alternative Dispute Resolution System. The experiment of Lok Adalat as an alternate mode of dispute settlement, it has come to be accepted in India as a viable, economic, efficient and informal one. The Lok Adalat is another alternative in judicial justice. This is a recent strategy for delivering informal, cheap and expeditious justice to the common man by a way of settling disputes which are pending in the courts and also those which have not yet reached courts by negotiations and conciliation and so on. Statutory status of Lok Adalats. The first Lok Adalat camp in the post-independence era, it was organized in Gujarat in the year 1982. This initiative proved very successful in the settlement of disputes. Consequently, the institution of Lok Adalat, it started spreading to other parts of the country, and at that time this institution, it was functioning as voluntary and conciliatory agency without any statutory backing for its decision. In the wave of its growing popularity, there arose a demand for providing a statutory backing to these institutions and the awards given to Lok Adalats. And hence the institution of Lok Adalat, it has been given a statutory status under the Legal Services Authorities Act 1987. And the Legal Services Authorities Act, it made certain provisions that relates to the organization and functioning of the Lok Adalat. That is, every Lok Adalat organized for an area, it shall consist of such a number of serving or retired judicial officers and other persons of the area as it is specified by the agency organizing such Lok Adalats. A Lok Adalat shall have the same power that is vested in the Civil Code under the Code of Civil Procedure 1908. The Lok Adalat, it can deal with not only the cases that is pending before a court, but also with the disputes at the pre-litigation stage. It can also deal the disputes that is pending at the pre-litigation stage. An award of the Lok Adalat, it shall be deemed to decree of a civil court or an order of any other court. Every award that is made by the Lok Adalat, it shall be final and binding on all the parties to the dispute, and no appeal shall lie to any court against the award of the Lok Adalats. Benefits of Lok Adalats. According to the Supreme Court, the benefits under Lok Adalats are: there is no court fee, and if it is paid already, it will be refunded if the dispute is settled at the Lok Adalat. The basic feature of the Lok Adalat are the procedural flexibility and speedy trial of the disputes. And there is no strict application of procedural laws like the Civil Procedure Code and the Evidence Act while assessing the claim by Lok Adalat. The parties to the dispute, it can directly interact with the judge through their counsel, which is not possible in regular courts of law. The award by the Lok Adalat, it is binding on the parties and it has the status of a decree of civil code and it is non-appealable, which does not cause the delay in the settlement of the disputes finally. The Law Commission of India, it summarized the advantages of Lok Adalats as: it is very less expensive, less time consuming, it is free from technicalities, conducting of cases in the law courts, and parties are free to discuss their differences of opinion without any fear of disclosure before any law courts. Parties have the feeling that there is no losing or winning side between them, but at the same time their grievance is redressed and their relationship is restored. Permanent Lok Adalats. The Legal Service Authorities Act 1987 was amended in the year 2002 to provide for the establishment of the permanent Lok Adalats to deal with the cases that is pertaining to the public utility services. The salient features of permanent Lok Adalats are: the permanent Lok Adalat shall consist of a chairman, and this chairman should be a district judge or additional district judge, or he should held an judicial office which is higher in rank than that of the district judge, and other 2 persons having adequate experience in public utility services. The permanent Lok Adalat shall exercise jurisdiction in respect of 1 or more public utility services, such as transport services of passengers or goods by air, road and water, postal, telegraph or telephone services, and so on. The pecuniary jurisdictions of the permanent Lok Adalat, it shall be up to Rs 10 lakhs, and however the central government, it may increase the said pecuniary jurisdictions from time to time. The permanent Lok Adalat will not have jurisdiction in respect of any matters that is relating to an offence which is not compoundable under any law. Family Courts. The Family Courts Act 1984 was enacted to provide for the establishment of family courts, and with a view to promote the conciliation and to secure a speedy settlement of disputes which is relating to marriage and family affairs. The salient features of family courts are: it provides for the establishment of family courts by the state governments in consultation with the high courts. It makes it obligatory on the state government to set up a family court in every city or a town with a population that exceeds 1 million. Family court, it enables the state government to set up family courts in other areas also if it is necessary, and it exclusively provides within the jurisdiction of the family courts that the matters relating to the matrimonial relief, such as divorce, judicial separation, restitution of conjugal rights, the disputes that relates to the property of the spouses or either of them, declaration as to the legitimacy of any persons, and so on. Family courts, it provides for only one right of appeal which shall lie to the high courts. Salient features of Gram Nyayalayas. The Gram Nyayalayas Act 2008, it was enacted to provide for the establishment of Gram Nyayalayas at the grassroots level for the purpose of providing access to the justice to the citizens and their doorsteps to ensure that the opportunities for securing justice are not denied to any citizens due to social, economic, or other disabilities. The salient features of Gram Nyayalayas are: the Gram Nyayalayas, it shall be a court of judicial magistrate of the first class, and its presiding officers, that is the Nyayadhikari, shall be appointed by the state government in consultation with the High Court. This Gram Nyayalayas, they are established for every panchayat at intermediate level. In a district where there is no panchayat at intermediate level in any state for a group of contiguous panchayats, the Gram Nyayalayas, they shall try criminal cases, civil suits, claim or disputes which are specified in the first and second schedule to the Act. The Gram Nyayalayas, it shall be a mobile court, and it shall exercise the powers of both the civil and criminal courts. The Gram Nyayalayas, it shall exercise the powers of civil courts with certain modifications, and it shall follow the special procedures as it is provided in the Act. And the Gram Nyayalayas, it shall try to settle the disputes as far as possible by bringing about the conciliation between the parties, and for this purpose it shall make use of conciliators which are appointed for this purpose. See you in the next session with some other interesting topic. Thank you.